Thank you so much. It is wonderful to be here. You know, I hope we all get the irony and the wonderful nature of having a Tea Party meeting in a British pub. You know, that just is wonderful. Alan hosted us for dinner last night, and if you think this breakfast was great, you ought to come back for dinner here. It is absolutely wonderful food and a great atmosphere. The meals are great, the desserts are greater. It is a wonderful place, and I'm just really happy to be here. Have a number of my homeschool friends here I've seen this morning. I want to say a special hello to Gavina and Ruth Perez, who are here. They're longtime leaders and members of the San Antonio Homeschool Movement and this whole area of Texas. They've been on the board of Texas Homeschool Organization for a long, long time. So we appreciate them being here. In fact, it was a Texas homeschool mom that hooked me up with Mark Meckler to explain the whole idea of the Convention of the States. This is an idea that I started talking about right after the November 2012 election. It's something that I've been doing for a long time. I'm a lawyer, been in practice for 38 years, I guess it is. I started practicing law when I was 7, and when I was a very young lawyer, one of the first cases I did was on Article 5. And that was when Congress tried to manipulate the process for the ratification of the Equal Rights Amendment. They tried to change the rules in midstream. And when they tried to change the rules by adding another 3.5 years for ratification onto the Equal Rights Amendment, when it was already in the domain of the states, I represented 4 Washington state legislators and challenged the constitutionality of that manipulation of the process. My case ended up getting consolidated when the case was filed after mine in federal court in Idaho, and legislators from Idaho and Arizona had also sued. We all joined together and worked together, and we won that case in the federal district court, and the court held that when you start the Article 5 process, whatever the rules you start with are the rules you stay with. There's no change to the rules in the middle of the stream, which is a very important ruling. Now, that case went to the Supreme Court. The Supreme Court accepted it, but then froze it because the second deadline was coming to a pass. And they let it pass, and when 38 states didn't ratify, they said the case is now moot. And so the case doesn't set an official binding U.S. Supreme Court precedent, but it sets a pragmatic precedent about what the rules are for Article 5. And more importantly, for me personally, it made me a student of Article 5. I went back to the National Archives. One of my jobs on this case was to go into the National Archives and physically read all the original ratification documents from every state from the 13th Amendment forward to modern history, and I did that. And we're looking at the lawfulness of ratification documents passed by the various states. And so I became immersed in Article 5, and I'm one of the few lawyers in the United States that has actually litigated an Article 5 case. And we wrote briefs in the Supreme Court. We didn't get to do oral arguments because of the mootness issue. But I argued actually an interim motion in that case in the Ninth Circuit Court of Appeals for that case. And Senator Sam Ervin wrote me a thank you note. He liked my oral argument so much that that's one of my real pride and joys as a young lawyer to get a letter from that country lawyer from North Carolina. I believe in the Constitution, but there's 2 different constitutions in this country. There's the Constitution as written, and there's the Constitution as interpreted by the Supreme Court. I don't believe in the Constitution as interpreted by the Supreme Court. I'm one of the few constitutional lawyers who say that. And when people say we don't follow the Constitution anymore, I get it. I get what they mean. What they mean is that we don't follow the Constitution as written. And that's mostly true. Now, we actually do follow the Constitution as written once in a while. It's like a broken clock. A broken clock tells the correct time once a day for 1 second. And so the rest of the time gets it wrong. So the Supreme Court gets it right once in a while. The 2 most recent Supreme Court decisions on the Second Amendment, the McDonald case from Chicago, the Heller case from Washington, D.C., they got it right on those 2 cases. They followed the original meaning of the Constitution, and they discussed it very, in terms of the original meaning of the Constitution. It wasn't an accident that they got the right answer. They actually got the right answer using the right methodology called the original meaning of the Constitution. Once in a while they get it right, but the vast majority of the time they get it wrong. I don't want to live in a country where these are the constitutional rules. I'm going to give you two examples. The first rule is the rule from Justice Roberts in the Obamacare case. I wish Justice Roberts would resign from the Supreme Court, not for the reason that you'd think, but because I hope he runs for political office, because I'd like to give him his first campaign donation of 30 pieces of silver. And so what Justice Roberts ruled in the Obamacare case was this: that there is no constitutional limitation on the power of Congress to tax and spend. The General Welfare Clause, according to Justice Roberts, not Justice Thomas, Justice Roberts, is that Congress can tax and spend for any purpose it wants. I don't want to live in a country where Congress has unlimited power to tax and spend. That's not the way our country was designed, that's not the way our Constitution was written, and that is not the original meaning of the General Welfare Clause. And if you read Joseph Story's original, very early treatise on the Constitution, you can find out what the original meaning of the General Welfare Clause, and it's completely different. Basically, in short terms, it was this: if the states can spend money on the topic, the federal government can't. That's what the original meaning of the General Welfare Clause was. So just apply that real simply. Can the states spend money on education? Yes. Can the federal government? No. Can the states spend money on welfare if they want to? Yes, if they want to. Can the federal government? No. You just fix that rule, the federal deficit would not exist. If we would follow the original meaning of the General Welfare Clause, there would be no federal deficit. In fact, the $3 trillion federal budget in round numbers would be, in round numbers, $1 trillion. That's still a lot of money, but that is anorexic compared to the federal government that we have today. The second thing the Supreme Court has said approximately 30 times, there is no check or balance on our power as a court other than our own sense of self-restraint. The founders did not intend to give the Supreme Court that kind of power. And the reason they didn't think they were giving them that kind of power is because they didn't have the idea of a living constitution. They had the idea that we were not creating a government of laws, of men, rather we were creating a government of laws. And what that means is judges follow the law as written. They don't get to change it according to their own personal political opinions. But when the Supreme Court is allowed to discover new rights, when the Supreme Court is allowed to reinterpret the Constitution according to current times. Now, let me just stop there and just, as a constitutional law professor, teach you a difference between interpreting old principles to new facts and new principles. Old principles to new facts is this: if the government spies on your computers, that's a violation of the Fourth Amendment, even though the Fourth Amendment says papers and effects. It's not literally paper, but it's still written. The meaning of the phrase is your written documentation. And so it's not a living constitution to apply old principles to new facts. What's the living constitution, what's tyranny, what's wrong when the court does, is when they change the principles of the Constitution. That's the problem. And when they invent principles like unlimited spending, they invent principles like Roe versus Wade, when they invent principles like the president can sign an order and go around the necessity of Congress to pass laws. Because by the way, any organization, I don't know what the most important rule is, any organization, whether it's the women's ministry in the church, whether it's the student body at Patrick Henry College, whether it's the United States Congress, whether it's the UN, the most important rule is this: who has the power to make the rules? That's the deal. And in the Constitution, the most important principle is Article 1, Section 1. All legislative authority is vested in Congress in the United States. So when Obama says that he has a pen and a phone, he can make whatever law he wants, I don't know what the phone has to do with it, frankly. Maybe that's where he's getting the orders from Saul Alinsky or something. I don't know. But the pen part I do get. And all legislative authority is vested in the Congress of the United States. That's what's supposed to happen, is that Congress makes the law, because if we don't like the law, we can vote the rascals out. You can't vote the Supreme Court out. You can't vote the bureaucracies out. You can't vote the UN out. You're supposed to be able to vote out the rascals. And so the only people who have the moral authority to make law, the constitutional authority to make law in this country, are supposed to be the people themselves or their elected legislative representatives. That's it. Nobody else. And we're violating these things every day. I don't want to live in a country where other than the people themselves and their elected legislative representatives can make law. I don't want a president with a pen and a phone. I don't care if he's a Republican. I don't care if he's a Democrat. I don't care if he's a member of the Constitution Party. I don't care if he's a member of the Green Party. I don't want any tyrant making laws, because the founders would call anybody who purports to make law other than the people themselves or their elected representatives, they would call them what they are tyrants. And